Okay, welcome, ladies and gentlemen. Today's episode. First of all, I'd like to welcome Sean back. We haven't seen him in a minute. He's been busy. But today we're going to talk about the Supreme Court case, specifically the arguments in front of the Supreme Court regarding the tariffs. You guys have heard about these tariffs left and right. What they're wondering, and the thing that has been brought up, is can the president even do tariffs? Yeah. So the obviously deep state, the Democrats, the powers that be don't want the president to have that kind of power. They've sued against it saying, stop this, stop this. He can't do that. And it's gotten all the way up to the Supreme Court, and they are making their arguments in front of the Supreme Court now. Now, I'm here to tell you, this is a long ass video. This is almost 5 hours long. So luckily, Sean was able to pare that down and get right to the heart of the matter. So we're just going to jump right in.
And this is the Supreme Court what's it called? Supreme Court blog that's on the internet.
Oh, the SCOTUS blog?
The SCOTUS blog.
This is the lady that writes SCOTUS blog. Okay.
How?
Okay, so let's
So she talks about the case a little bit as we open it.
Okay, so yeah, what's her name again?
Amy Howe.
Amy Howe. Okay, I've seen the SCOTUS blog. As a matter of fact, we've referred to it before on this channel.
It's amazing.
It's incredible. It is completely. It is the least biased thing I have ever seen in my life. Kudos to this lady. She doesn't lean one way or the other in the reporting. She literally just says what happened. My God, man, it's like a real reporter. We haven't seen one of those in a minute, have we?
But yeah, she does great work.
She does. I've been a huge fan. I followed it. I highly recommend it. It's called SCOTUS blog.
I follow them on Twitter.
Yeah, I recommend it. So we're going to let her explain what's going on. She's 2 minutes, 20 seconds, and she'll kind of fill us in. So here we go.
Good morning. How are you?
Good morning. I'm doing well. It's a beautiful day here.
So, Amy, explain to us the legal question here that the Supreme Court will hear arguments about.
So, imposing these tariffs that are at the center of the case, President Donald Trump relied on a 1977 law called the International Emergency Economic Powers Act that was enacted in 1977. Okay. And no president before Donald Trump has relied on this law to impose tariffs. The law gives the president the authority when he declares a national emergency, and I'm paraphrasing a little bit here, to regulate the importation of property in which foreign countries or foreign nationals have an interest. And so the question is whether or not the authority to regulate importation gives the president the power to impose these kinds of tariffs.
And when you...
It's an interesting question. Like, I understand, like, some of this stuff. It's ridiculous that it ever ended up in front of the Supreme Court. This one, I actually get. I understand why this is making its way up.
Because it could go fall under the legislation.
Right, which is their claim. The legislature sets all... there's a weird argument that they make about, like, whether you actually generate income from it or all of this.
That's a big part of this case.
Yeah, we'll get into that.
You say that no president has used it before, then why was it there? What was the impetus for having that?
Well, presidents have used it in other contexts for embargoes, for sanctions, for blockades, but they haven't used it to impose tariffs. And so that's one of the challengers' arguments is that, no one has ever understood this to include tariffs. And there's nothing in the text of the law, which has the somewhat unwieldy acronym IEEPA, that says anything about tariffs.
And what are the kinds of tariffs that are at issue here?
So there are two kinds of tariffs. One bucket of tariffs are commonly called the trafficking tariffs. And those are imposed on goods from Canada, China, and Mexico because Trump says that those countries haven't done enough to keep fentanyl from coming into the United States. And then the other kind of tariffs are called what we call the reciprocal tariffs that Trump has imposed because of what he calls large trade deficits. And those are imposed a baseline tariff and then tariffs of up to 50% on virtually all countries with which the United States has trading relationships.
And when we talk about the fentanyl and the trade deficits, is that what the administration is arguing is the emergency here? That fentanyl coming in is an emergency and a trade deficit?
Deficits are an emergency, exactly.
So you're going to be in the, you're going to be watching the.
Okay. So she brought us up to speed. That's where we ended anyway. So there are a few interesting points that are coming up in this, I think. Number one is state of emergency, right? The government declares emergencies for everything. I mean, all they have to do is declare an emergency and suddenly their power is greatly broadened. I'm sure you guys can remember the big event that happened in 2020 where all of a sudden the government had way more power because of emergencies. So if they can use these emergencies to do things like we're done, then can't they use these to generate tariffs, to enforce tariffs on other nations? And we're going to get into the arguments and all of that, but it is an interesting question. And I think it is a constitutional question. Like it's something that they're going to have to decide based on, is this legal or not? So, all right, we're going to jump ahead to so Trump's name is, I think, the same spelling even. The name of Trump's attorney in this, or the executive branch, is
the Solicitor General.
The Solicitor General. His name is John Sauer, like Sig Sauer. And I don't know if they're related. I don't think so. But Sig Sauer has had their time in the news recently. So it's going to be an interesting dynamic.
I didn't even hear about that.
Yeah, and from my understanding, there's a little bit of, I guess, controversy over this guy, and allegedly he's talking like super fast during this, like car salesman fast. I don't know. I haven't watched it. Would you agree or
Not
disagree
that I
with
remember,
that? No?
But we'll
Okay.
see. Maybe.
Yeah, we're going to jump right into him at the 158.41 mark. So we jump way ahead. Oh, okay. So it looks like they just got started here. Okay. All right. So here we go. All right. So D. John Sauer, U.S. Solicitor General. We're going to pick up on him, and we have looks like around 2 minutes of him.
Yeah, the opening.
Here we go.
Thousands of American lives. President Trump has declared that these emergencies are country killing and not sustainable, that they threaten the bedrock of our national and economic security, and that fixing them will make America a strong, financially viable, and respected country again. Due to IEEPA tariffs, President Trump has negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences. In Dames and Moore against Regan, this court held that IEEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEEPA's least blunt and most nimble tool, are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulated importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEEPA authorizes quotas and other tariff equivalents. The major questions doctrine does not apply here. IEEPA confers major powers to address major problems on the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs, where he enjoys his own inherent Article II powers. I welcome the.
Okay. He does make some interesting arguments there, in my opinion. In the past, according to him, the court has taken a very wide latitude with the powers granted in here. And so why now at this late juncture are they all of a sudden saying, oh, no, not that. Everything else, yeah, but not that. So that's a valid question. It's a valid point. We're going to jump right into Clarence Thomas, which I got to find I don't find the beginning. I want to pause. Okay, yeah, we're just going to jump right into Clarence Thomas. Here we go.
Court's questions.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of foreign, international crises, so to speak, in foreign arising emergencies, that's sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson in his Youngstown opinion addressed this very situation in pages 652 and 653 when he says, this is the system within this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have robust powers to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad and necessary powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEEPA. So that's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president, who has his own broad range of major authority, inherent Article II authority in this context. And that is buttressed by the second point, which is
General there, and I know.
So we're getting a little bit of audio issue here. I don't think it's on my end. We've had issues in the past with this, so we're going to keep going and fingers crossed. But we're going to jump right into Kagan here for about 2 minutes, who has a question.
That you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent Article II powers. And I'm wondering what exactly, which powers you're speaking of there, because tariffs, one would naturally think is are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, on Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's been debates about exactly how far it goes and how to draw the boundary between the president and Congress. But Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies. Now, we don't contend that he has, at least in peacetime, inherent tariffing authority. What we have here is 2 layers. There's the layer, the bedrock of the president's, inherent Article II powers, and layered on top of that is a sweeping delegation of authority from Congress. When you put those 2 things together, Congress is saying you have inherent powers to address international emergencies, and we're conferring on you the tools, including Article I tools, like, for example, the power to regulate foreign commerce. And I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them. If they achieve their goals, if they
Counsel, you've already mentioned Daines and Moore three times, which surprises me a little because.
Okay.
And they always, it's between the executive and the legislature, and they always give up their power to the executive. We've seen so many times, and now they want to give that power back in this situation.
Right. And it's not just the executive branch. Congress has doled their power out throughout the years to all of these other 3-letter agencies. Congress is supposed to be the CIA, the FBI, the DOJ. All of these things are supposed to fall under Congress, DOJ being an exception. That's the executive branch that oversees that. But Congress, throughout the years, has doled away their power to various committees, to various organizations, to various agencies. They have whittled the power down. And now that they're practically toothless, almost, now they want to start clawing some of it back not because they don't believe that they did the right thing by giving it away, but because someone they don't like is in the office and they don't want him using it, even though they're okay with it going the other way. So, all right, we're going to jump ahead a little bit to, looks like Sotomayor, 20534. And we're going to go to 20810.
Understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue. I don't understand this argument that it's equivalent, or that foreign powers or even an emergency can do away with the major questions doctrine. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine in the foreign policy context.
But we
That's the
have,
emergency context, not foreign policy
counsel,
context.
we have never applied it to foreign affairs, but this is a tariff. This is a tax.
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's a regulatory tariff
Commerce,
distinct from a
everything.
tax.
So Biden could have declared a national emergency and global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's
perhaps he could
global,
have.
it's foreign
I don't agree with
facing.
that argument.
We need all of these things to face.
That makes no sense.
To tax fossil fuel or to do something else.
I'm going to pause it for a minute because that's a hell of a reach. That is one hell of a reach to say, oh, well, if the emergency makes everything okay, then he could have just, gotten his student loan forgiveness by declaring an emergency. He tried. He literally tried to sidestep the Supreme Court. And she's still, anyway.
That's all Biden would have had to do with any of his programs?
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
If I may, maybe I can articulate.
And what does student loans have to do with a climate emergency?
I think the question.
That's my, I think I get what she's trying to say, but what an absolutely abjectly awful comparison. Like, what a horrific example, in my opinion.
This way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEEPA naturally evokes.
Why
not the
is
power to
it,
tax.
could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing, that it used taxes simultaneously.
I mean, I think at this point it's just arguing definitions of stuff, but it'll be interesting to see how they rule on this. It really will. We're gonna jump ahead to good old Kavanaugh. Justice Kavanaugh, 213-35. There we are. I went way past it. Okay, this is not working. Oh, there we go. 213-35, Kavanaugh.
significance of the Nixon example and precedent here?
Did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon.
Just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, but for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power. So that whole sort of process gives sort of strong sort of confirmation this phrase regulate importation carries with it the power to tariff. Now, of course, that's not our leading argument. Our lead argument on interpretation is there's a pedigree, historical pedigree of regulating imports specifically, where the power to tariff is just the sort of a core application of that, a quintessential exercise of that power. That goes back to Gibbons against Ogden and Justice Story's treatise and runs all the way through cases like McGoldrick and Board of Trustees.
General Sauer, can I just?
Okay, and then jumping in here is Amy Coney Barrett.
And what
Ask
makes
you
it
a question?
what makes it okay for Nixon to be able to tariff and not Trump?
Right, and that's a very valid argument. Is Nixon did it? It was perfectly fine with him. As a matter of fact, after he did it is when they did this IEEPA crap and used the exact same language that Nixon used to impose those 10% tariffs.
I never knew Nixon did that.
I didn't either.
Until I saw this.
Yeah, but here's the thing. So they like to say, oh, no president has done this, right? Not under IEEPA, because IEEPA didn't exist until Nixon put tariffs, and they worded it the exact same way as it was before. So it's going to be hard to get over that, in my opinion. All right, so ACB here.
And can you point to any other place in the code or any other time in history where that phrase together, regulate importation, has been used to confer tariff imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's
Okay. So an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that
treatise
just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegates.
Could you just answer the justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IEEPA.
And then, of course, I mean, those are.
Okay. So anywhere other than the two instances that you talk about where it says that and means that, and he couldn't come up with any of that. So I think it's really hard to say, oh yeah, this justice is thinking this or this justice is leaning this way, because they do ask a lot of questions, which they should. I'm a big fan, but I have been extremely disappointed with Barrett in the past, and I see no reason for that to change. Okay, so we're going on to Kagan at 218.28 here.
Except Congress did.
The intention of Congress to sort of cover the waterfront.
Well,
to grant the
possible,
power
General, possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs, it has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue raising, like block and prohibit, I think that argument is unconvincing for two reasons. One, of course, is that we're not saying it confers a revenue raising power. We're saying it confers a regulatory power, and that's a crucial distinction. But also,
yes, but if I can just stop you there, regulatory power. I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
we don't assert that. We say it includes tariffing power when it's combined with importation, and that's just the most natural.
Right, because the natural understanding of regulate, even though in fact we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind. And then if you look at the flip side of this and you look at all the tariff statutes that Congress has passed, I mean, they use language about revenue raising, tariffs and duties and taxes, all the language that does not appear in the statute you rely on.
Okay. So her argument, and I think we're going to hear this a lot because I've seen a few clips, revenue raising. That's a big deal for them because of the way the codes are written. And ultimately, I think we all agree that any real financial power lies with Congress. They confer taxes, they collect taxes. Well, the IRS does because, again, Congress has given them an authority away. However, before I get off on a tangent, look, do tariffs raise income? Do they raise revenue? Or are they a different form of like financial incentives, financial incentives, whether pro or against, right? Changing the amount of tariffs is certainly going to have an effect. So, and I'm sure there are other arguments that we'll hear, but
there is. Yeah,
we're going to go to 224.53 for good old John Roberts. Not a huge fan.
Going back to the founding, going back to
the foreign commerce part. But I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs and dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mix.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different. Sometimes the foreign producer would pay them. Sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by.
I mean, it's been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an instance.
Okay. And that's a point is, okay, if they're being applied to our deficit, well, trade deficit is different than debt though, right? So I don't know.
And also the president's in charge of foreign affairs. So
Right.
I think they're going to try to balance this in some way.
Yeah. This is going to be an interesting one to watch, and that's why we're covering it. All right, we're going to jump ahead just slightly to Sotomayor at 226.53. Look at that, and then we're going to take that to 230.07. So just like a minute and a half.
Why not do what the statute permits? Bar importation of products altogether. That would be the most effective way to do it.
What the question?
You follow the statute. The statute says the president can do that. What it doesn't say is the president can raise revenue.
What it says is he can regulate importation and go back for hundreds of years. The way you regulate
quotas, causing it, subjecting some countries and not others to importation bans. There's a lot of verbs, but none of them include generating revenue.
That's going to be a tough argument. It is, because they agree there's a lot of power here. Regulate trade. Ooh.
And you got to remember, they're not just deciding this for Trump. They're deciding this for the people after Trump.
Exactly. Yeah, this isn't just Trump. This is going to carry over. So let's see here. A couple more slides.
As a side effect or directly.
Okay. Or jump ahead to my absolute favorite justice, Ketanji Jackson.
No sarcasm there.
No sarcasm. All right, 228.09 to 230.07.
I tried to get
a minute and a half of the stupidity.
The verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA, what it was doing. It said that what we are doing is authorizing the president, the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating.
No, I know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when in fact it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And again, if you're so worried about the history then you should just rule that Trump can do it because Nixon did. And you guys, the courts had no problem with it. Congress had no problem with it. As a matter of fact, they literally rewrote the stuff the same way. So I'm having a hard time, well, some of us care. Shut up. All right. So
that was a weak argument.
It was a very weak. All right. We're going to go back to actually my actual favorite justice, which is Justice Thomas. 234-48. I don't know why I keep putting these down, guys. I can't see. I can't see the little bitty numbers. What did I say? 234. Ooh, look at that. 234-48.
Area of Youngstown Zone 1.
A few times you have alluded to the history as being important in interpreting the statute, and also that this language comes from the Trading with the Enemies Act, and that has its own pedigree. Could you just sketch out this direct line that you were alluding to as a basis for interpreting the current emergency statute as you would like it interpreted?
Yes, Justice Thomas, and turning back to the response I was giving to Justice Barrett earlier, there is, I think it's very well set out in Professor Baumsei's amicus brief, there is this history of presidents using a tariffing power or a tariff equivalent power, very, very close to tariffing power, in wartime to tariff trading with enemies. And that is when the Trading with the Enemy Act was enacted in 1917, it was deliberately evoking that. And when it brings in the power to regulate importation, it's essentially codifying for an inherent power the president's already recognized to have. And then in 1933, when that power is expanded to an area where he wouldn't inherently have it, the peacetime context, that codification, the meaning of that remains the same. The regulate importation language that's brought in from TWIA and then ultimately to IEEPA in 1977 is carrying with it that connotation. And that's reinforced by all the cases we've cited in our brief where there's been extremely broad delegations of the power to tariff specifically and the power to regulate foreign commerce more generally, going back to the time of the founding, which ties to your question about non-delegation.
I'm starting to agree a little bit that this guy talks pretty fast.
He does talk fast.
He talked. Now, that's not necessarily a bad thing. I've known some very intelligent people who just spoke so fast because their brain was trying to keep, their mouth was trying to keep up with their brain. I've known a few people like that, super, super smart people. They just talk so freaking fast, man. It's like, okay, whoa, slow down. Slow down. I know you're getting excited. We're going to jump to Neil Gorsuch, 247-41. And good old Neil's not bad. I don't mind him. What do you think of?
I don't mind him.
I don't mind him. I think he tries to do the right thing, but a lot of times I've seen him just kind of
has a libertarian bent.
Yeah.
So yeah, he's his conservative / libertarian.
Mm-hmm. Yeah, I've noticed he's a little more strict on the interpretation.
Oh yeah.
He will almost always rule in favor of the people, which is how it should be, because any powers not assigned, et cetera, guys, come on, it's the Constitution. Any powers not delegated automatically fall to the states and then the citizens. So that's how it should be. Anytime there's a doubt, we should automatically win. But
not how it always works.
Yeah, we have had 200 years of 250. Yeah, we celebrated the 250th anniversary recently. So we will. Yeah, but next summer is 250. So we've had over 200 years of people trying to destroy the system the founding fathers put in. All right, let's get old Neil here.
Versus the need to address unforeseeable.
Thank you, General.
Justice Gorsuch.
General, just a few questions following up on the major questions discussions you've had. You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit, to lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now in 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying
we
shouldn't be concerned with. I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute again that has a whole.
I'm not asking about the statute, General. I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions of non-delegation, what bite it would have in that case.
I would say by then you had moved from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that, there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale application of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply. At least
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would.
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay, all right.
That would be, I think, an abdication. That would really be an abdication, not a delegation.
Yeah, you just pour him apart.
Yeah, you ripped him a new one.
Yeah.
That's the thing, man. I'll give Gorsuch one thing. He knows what he's talking about. When he starts in on somebody, I've seen this before, like he already knows the answer. He's just waiting for them to figure it out. And he's a smart dude. Cut the legs right out from under that argument. But you know what? It is a good argument. It's a good question. Let's say that. It's a good question. Since Congress, for the last over 200 years, has systematically reduced its power and handed it away, what's to stop them from here's an example. What's to stop Congress, not necessarily from giving it to the president, but creating a bureau that the only thing they do is decide when we go to war?
That's frightening, but yeah,
what's to stop them?
Yeah.
They've delegated everything else away or abdicated, as he says, like whatever you want to call it. All right. That's kind of our intermission. I recommend you grab a snack. We got a little bit of going here. All right. We're going to jump ahead to Neil K. Katyal.
Yeah, that's for the other side.
Okay. So
there's three different people
on their side.
There's like states that are suing.
Oh,
so there's a third person.
I see what you mean. Okay. And we're going to the 1333. All right. And we're taking this to 31554. You say this is would this be the plaintiff then? And the government would be this would be, I guess, the plaintiff, and then they'd be the respondent or the defendant or whatever. And so these are the people, though. This is one of the attorneys representing the states that are suing.
That's the next person. I don't remember who this is for which side this, but the state's one is next.
Okay. Oh, we got.
It's a Solicitor General for the state of, I want to say Oregon or
Okay.
Washington next.
Well, let's dive in. Let's see.
All right.
Neil Katyal. Neil K. Katyal.
Thank you, Mr. Chief Justice, and may it please
Okay, it says here, lawyer for companies
Okay, that's
against
the company.
tariffs. All right.
the court. Tariffs are taxes. They take dollars from Americans' pockets and deposit them in the U.S. Treasury. Our founders gave that taxing power to Congress alone. Yet here, the president bypassed Congress and imposed one of the largest tax increases in our lifetimes. Many doctrines explain why this is illegal, like the presumption that Congress speaks clearly when it imposes taxes and duties, and the major questions doctrine. But it comes down to common sense. It's simply implausible that in enacting IEEPA, Congress handed the president the power to overhaul the entire tariff system and the American economy in the process, allowing him to set and reset tariffs on any and every product from any and every country at any and all times. And as Justices Gorsuch and Barrett just said, this is a one-way ratchet. We will never get this power back if the government wins this case.
True.
What president wouldn't veto legislation to rein this power in and pull out the tariff
True.
power? IEEPA is a sanction statute. It's not a tax statute where Congress gave away the store. Congress knows exactly how to delegate its tariff powers every time for 238 years. It's done so explicitly, always with real limits. IEEPA looks nothing like those laws. It uses regulate, which Congress has used hundreds of times, never once to include tariffs, and it lacks the limits of every other tariff statute. And that is why, even though presidents have used IEEPA to impose economic sanctions thousands of times, no president in IEEPA's 50-year lifetime has ever tried to impose tariffs. And the president bypassed statutes that do address tariffs, like Section 122 for large and serious trade deficits, but that imposes a clear guardrail, 15% cap, 150-day limit. This is Youngstown at its lowest ebb. If the government wins, another president could declare a climate emergency and impose huge tariffs without fines or without floors or ceilings, as Justice Gorsuch said. My friend's answer, this administration would declare it a hoax. The next president may not quite say that. This is an open-ended power to junk the tariff laws and is certainly not conveyed by the word regulate. I welcome the court's questions.
I mean, it's a pretty straightforward argument. And the one thing that he said that I absolutely agree with is if we give the president this power, Congress will never get it back.
No.
Once they decide this, if they decide, yeah, he's good to go, he's going to run buck wild. Like, just be aware. And I'm not saying I'm for or against that because I don't know enough about it. All I see is what people say. I don't know. I know the economy sucks right now. I know that everything's fucking expensive. So if that's why, knock it off. That's all I have to say on that. But okay, we're gonna jump to Clarence Thomas. Actually, just let it play. Here we go.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue, as some of your own opinions said. This is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. And, you know, there was no Boston embargo party, but there was certainly a Boston Tea Party. The second thing, textually, in the statute.
That was incredibly stupid argument. I had to point. That was what, my guy? Really? Bruh, come.
It's different. Regulate appears in a cluster of verbs, as was said before, investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The one verb that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there's a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes. And indeed, the history of this is very, very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel,
I see what he's saying, and I will say he is very well read on the statutes. Good for him. I think he might be a little more well-read about this thing than Sauer, because Sauer seemed to struggle a bit to name exactly what he was trying to get across. That said, I don't necessarily agree with everything this guy's saying, but I'm not as versed in this as the justices, obviously. So, and it doesn't matter what I think anyway. It's not like I'm voting on the damn thing. So let's see here. All right, so we're going to go right into, I believe, Justice Roberts.
Yes, sure. The tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
We're quite effective in achieving.
Don't interrupt the judge. Whatever court you go to, even if it's regular traffic court, never interrupt the judge. I have seen judges lose their minds. There's a guy over people interrupting them and trying to talk over them. Remember, you ever see Judge Judy? She hates that crap, man. She will go off. Don't interrupt the judge. Anyway.
Even particular objective. So I don't think you can just separate it when you say, well, this is a tax, Congress's power. It implicates very directly the president's foreign affairs power.
And that's a valid point. If the president is the go-to for foreign affairs, it's a sticky thing. It's not an easy, and like he said, we didn't stay this case. We're hearing it. So
there's a lot of gray.
Yeah, there is a lot of gray area in this. All right, so we're going to jump ahead to Brett Kavanaugh here at 321.12.
Power, even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here, because every other tariff
I
statute
get as
has
applied to this
limitations.
case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs
Absolutely.
as a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And
Yeah. And that really is the crux of the argument, because this statute that they did after Nixon maintained that language. So what does that mean? That's the crux of the entire argument. All right. Samuel Alito, 325.52. And that's going to go to 331.25.
Park that's very crowded. What if there were a statute that said, I mean, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park.
I see. Okay. So it doesn't raise revenue. It just offsets what they already spend.
Yeah, that's his argument.
It's all revenue, my guy. You can save that, in my opinion, because that's generating funds, period.
That may, those kinds of cases, which I think.
Suppose it goes beyond the cost of running the park.
Yeah.
Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then and it's not about that, then I think that's fine. If it does,
it raises revenue. Then
I think it's a tougher
hypothetical. That wouldn't apply.
So I think in that circumstance that it wouldn't be a regulation in context. It wouldn't be permitted. That is, at least in the context of tariffs and trade. We know, Justice Alito.
Well, that gets into your other arguments.
Right.
We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue raising? Suppose that instead of imposing these across the board tariffs, suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue raising tariff?
I take it the initial point and on its face, it is revenue raising. That's what it's for. And so I think that would. And look, I don't doubt that there are edge cases. That is what this court's confronted just recently in FCC versus Consumer Research. And you said, look, what is a tax is sometimes very hard. What is revenue raising? This is obviously revenue raising. Their own brief to the court says it's going to raise $4 trillion. And Justice Alito, you in your Consumers Research dissent, or Justice Gorsuch's dissent that you joined, said taxation is special and different. And it is the most powerful thing the government does. And the idea that Congress, when they know exactly how to write tariff and tax statutes, gave this power by implication through the word regulate, I think is very, very hard.
Well, you cite many different statutory provisions that impose tariffs. And you have a point if that's the relevant universe. What if the relevant universe is tariffs that are imposed in emergency situations?
Yes. So I think it cuts the other way. So, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, oh, the way to deal with that is I need to have a tariff authority. And as Justice Sotomayor said, IEEPA gives already a quota power, so you can get what the foreign policy piece of it is through that. I'd also say, Justice Alito, Dames and Moore, which the Chief Justice referred to earlier, I think is really important here, because the Solicitor General in that case made a similar argument to what you just heard. On the claims provisions. He said it falls within regulate. Regulate is a capacious term. He said, Justice Alito, what you said, this is an emergency situation. And he said you've got to defer to the president on a major issue of national security about this very statute. And what did the court do? It rejected those arguments and said IEEPA doesn't cover this.
You say that this is not, this case does not, these executive orders do not address an unusual and extraordinary threat. I understand that argument. Suppose that the facts were that it was suppose that there was an imminent threat of war, not a declared war, but an imminent threat of war with a very powerful enemy whose economy was heavily dependent on U.S. trade. Could a president under this provision impose a tariff as a way of trying to stave off that war? Or would you say, no, the president lacks that power?
Couldn't do tariff, but could do quota, embargo, all of those things.
Could do all those things, but the president could not impose a tariff. That's the one thing he couldn't do.
There's a category shift between a tariff and the other 8 powers in IEEPA because it is revenue raising. So it's not a difference in degree or something like that. That's why, I don't doubt tomorrow.
Even if the purpose of this had nothing whatsoever to do with raising 1 penny. The president didn't want to raise 1 penny. The president wanted to deter aggression that would bring the United States into a war. You would say, no, can't do that.
Yeah, just Alito, I think you've said many times the purpose isn't what you look at. You look to actually what the government is doing. And if you
I mean, he's just not willing to give anything, is he? I mean, I get it. That's his position. By going, oh, yeah, that would be, then he would undermine his own argument. But I don't necessarily agree with him. And it was an interesting question from Alito is if the intention is not to raise revenue, but it is instead used as essentially a threat to change a country's behavior, does that still apply? Oh, yeah, it still applies. You couldn't do that. But it's not raising revenue. Well, the point is to raise revenue. Not necessarily. Anyway, 342, 17. Yeah.
It should be Alito again.
Some more Alito. 342, 17.
an emergency. That's what it's about, and it's limited 15%, 150 days.
I mean, what about the authorization for the use of military force in 2001, which gave the president the power to use all appropriate force? Now, that's pretty open-ended. Would you apply the same non-delegation argument there that you do here?
Of course not, because there you have shared powers between the president in Article 1 and Article 2 powers. That's what I was saying.
Well, it gets into the question of whether it was delegated or not. What was the scope of the delegation?
Absolutely, but there, it's military. There's a whole unique history behind that. But here you're talking about something that is exclusively committed to Congress in Article 1. And there, yes, when you have delegations, I would say, Justice Alito, even when you have delegations in some military cases, in emergency statutes, they have all sorts of limits. So 10 U.S.C. 2808 says that in a declaration of war or a national emergency, the president can, quote, undertake military construction necessary to support emergency use of the armed forces, but it has limits.
I think that might be the answer. To have Congress give the permission, have like something similar to the AUMF where the president Congress gives their authority that he can do tariffs.
Yeah, but under certain limited scopes.
That might be the answer.
That might be. I will say that I'm not necessarily against there being some limits, some some sort of control on this, because right now, if you assume that they're telling the truth, that not even that, if you assume that the statute means what it used to mean with Nixon, and okay, yeah, tariff away, there are no limits set on that, and he could go buck wild, he being Trump.
Or any other future president.
Or any other future president, like they said, Biden or somebody like him could easily go, oh, we have a climate emergency. They already tried that shit before. We have a climate emergency, so we need more money, so we're going to put a 20% tariff on everything.
A tariff on fossil fuels.
Right. Yeah, exactly. So, yeah.
Gavin Newsom could easily do that if they...
Yep.
He's probably going to be the nominee probably in 2028.
It'll be interesting to see who they go with. I think there's a very good chance that we're going to see Newsom put his hat in the ring.
Oh yeah, he's
for
running.
Sure. Yeah, it'll be interesting to see who else steps up. And the last one, oh my God, I don't watch DNC stuff, but that freaking presidential debate they had. Oh, that was a barrel of laughs from the beginning. How many of you are going to give health care to illegal immigrants?
Every
single one of them. Bruh. And then going to sit there and say, oh, we don't do that. No, no, we can't do that. We haven't done that.
They prioritize illegals over U.S.
citizens. Look at Chicago, dude. Chicago's a perfect example. All right, let's
go back to the Supreme Court.
Yeah. Okay. So we got about a minute and a half of Sotomayor here, and then a couple minutes of Barrett, and then we'll move on to the last of the three sections.
Justice Sotomayor?
I'm fascinated that the two instances where presidents have used their war powers to impose a tariff, Lincoln and Nixon, that Congress found it necessary to ratify their actions, and that the court in both those cases, the Intermediate Court of Appeals in Nixon and our own court, included that as part of their reasoning, as justifying the use of war power in that situation. So I'm a little concerned why the fact that this act, a domestic act on emergency that uses a general word like regulate, should take on a war powers meaning when in every other situation, whenever Congress intended domestic taxation, it said tax and regulate.
Oh, Justice Sotomayor, I wish I had an hour to talk about this with you, because this argument by the government advanced in their reply brief is wrong, every which way.
I'm saying that's your sixth way of differentiating your CETA, correct?
So
that was a war powers case.
So it's a war powers case. It's about conquered territory. It has nothing to do whatsoever with domestic tariffs. And absolutely, you're right in saying that the way that court, even in those cases, even at the height of the government's power, war powers, they said Congress had to ratify it. And that's what at page 96.
And that hasn't happened here.
And that has not happened here, not even close.
Well, it might.
Okay. I didn't quite understand what all she was saying other than handing him a softball. Here's why you should be against this. But maybe I misinterpreted it. That's always possible. All right. So there we go. All right. So at the 4 hour and 13 second mark, yes, 4 hours, guys. And we got another half an hour or so of the clip itself, but Sean has cut it down to looks like 2, 4, 6, 8, maybe 10 minutes left, guys. We're almost done. Hang in there. I would recommend getting some crackers and cheese, though. Dude, I love crackers and cheese, man.
So do I.
What kind of cheese do you like with your crackers and cheese?
Swiss.
Interesting. Okay.
Yeah.
What's your favorite crackers to do cheese and crackers with? I'm more of a sharp cheddar guy. I like especially but it gets weird. If you go too extra sharp, it gets this weird aftertaste to it. but sharp cheddar. Yeah. I like Colby Jack. I like cheese. I just like.
Oh, I like cheese.
But you like the club crackers, the Ritz crackers, the Ritz. Yeah, Ritz is good. Ritz is good. All right.
I'm sorry, could you say that again?
Could the president regulate commerce under IEEPA by using a licensing fee?
Not a fee. So I should have said this earlier, but license is different from a licensing fee. IEEPA and TWIA authorize licenses, not license fees, and no president has ever charged, to my knowledge, fees under those two statutes for the licenses. So fees impermissible, licenses okay.
Fees permissible if they cover the costs of the scheme?
Might be. I mean, but once they start revenue raising, you implicate the most serious concerns.
But I thought you conceded to Justice Gorsuch there was no difference between a tariff and a licensing fee functionally.
If the licensing fee is just to, I didn't concede that. And so if the licensing fee is just to recoup the cost of government services, I think that may be okay. I don't think you need to get into it. Here, the government is asserting a power which they say in their briefs to you raises $4 trillion.
So you understand the statute to permit licensing in the sense of permission. Like, we will not allow you to trade with us. We will not allow your goods to be imported unless we license it.
Absolutely. And Justice Barrett, I think like just the natural reading, if you're to look at the word licenses and think, wow, Congress smuggled this incredible power to do all of these different things that the government is doing here, 39% taxes on some countries and others, through the word license.
Can you license exportation?
I don't think so, for the reason that,
Well, right now, I actually looked into this. I mean, I think you, maybe not licensing fees.
Exactly.
But could you license exportation, like saying we're not going to allow certain products that have national security implications to be exported?
Yes.
So licensing could be used in that sense,
Correct.
not as a revenue raising measure.
Yes.
Okay. So you.
Okay. So you can license, but you can't license. You can license, but you can't raise money with it. But wait, you can do what I said you could before, which was offset the cost. So you can charge for it. I don't think he knows. I think he's doing his best to maintain his stated position without conceding. Yeah, that counts.
Work. She kind of got him.
She did get him. Yeah. I'm kind of proud of her. Good job. Anyway. This is our third segment. So if you got that crackers and cheese, now would be a good time to cut some cheese, put it on your crackers, get ready while I get our next little clip here. Benjamin Gutman.
I'm not sure how you pronounce it.
Yeah,
Gutman?
This is the tertiary individual, and we're going to 410 something. 410.06. We're going to start right here. Here we go.
Mr. Gutman?
Good.
Mr. Chief Justice, and may it please the court. I'd like to begin by picking up with the exchanges with Justice Barrett and Justice Gorsuch about licenses and license fees, because I think we ended on the right note, but I just wanted to make sure that at least my client's position is clear on this. Licenses are different from license fees. And I am not aware of any history in the 5 decades that IEEPA has been in force of any fees charged for the licenses under this statute. This is a statute that licenses can be used. For example, the president might ban certain transactions with a foreign country, but then grant licenses to do them for humanitarian reasons. But as far as I'm aware, there's never been a fee charged for that. And I do welcome the court's questions. But I think I just want to make absolutely clear.
I think the question is.
Okay, and then we're going to jump. We're just going to carry it in. As a matter of fact, this next section, we're going to go for a little bit. It's going to be Justice Gorsuch, Justice Barrett, Justice Kavanaugh, and then we'll get back with you. So you got a couple minutes. Enjoy the crackers and cheese.
What does or otherwise do?
Well, or otherwise could be of things like instructions or licenses, but again, it's fundamentally having something that is a revenue-raising measure or even that is just an exaction of some sort is fundamentally, categorically different from what we understand instructions and licenses to be involved. Just like we think regulate doesn't carry the financial connotation given the other verbs there. If I could turn to some of the 19th century history that we were discussing as well, because I think there may be a little bit more to add there. The 19th century cases about the president's inherent Article II authority to, with respect to, in a wartime, with respect to importation is not the power to impose tariffs on imports coming into the United States. That is not what any of those cases were about. They were about the president's power, in a wartime as an occupying military force to impose tariffs in occupied territory, that in Mexico, in the Philippines, in California. The Civil War case might be the closest case, but even there, what we were talking about were essentially, there were licensing fees, but they were export fees. They were fees that were being imposed on the exportation of cotton from the occupied South into the North. And so I don't think any of that provides authority for this general notion that there is a background principle that the president, even in wartime, has an Article II authority to impose tariffs, certainly without the consent of Congress.
So you agree, I assume, given all the verbs on this list, that the president could do something like just shut down all trade between us and, say, China, right?
Yes, I mean, there are other limitations in the
Okay,
statute.
so doesn't it seem, and I think this is one of the points that Algonquin makes, and I think it's a point that Justice Kavanaugh was making, doesn't it seem then, I mean, I don't want to use the phrase lesser power, lesser included measure, but doesn't it seem like it would make sense then that Congress would want the president to use something that was less, weaker medicine than completely shutting down trade as leverage to try to get a foreign nation to do something?
And the president can in the form of, for example, quotas. But what makes an embargo or quotas fundamentally different from tariffs, as my friend has already explained, is the revenue raising aspect of that. That makes it a far more significant power. It creates additional danger of overuse. And I think the other point, as Justice Jackson was pointing out, is that it cedes control over whether the transaction occurs from the government to the individuals engaging in this transaction. And that is not what IEEPA is intended.
What makes something revenue raising? I mean, fees raise money, and
Yes.
unless
Right.
they're going to be kind of one-to-one, this is exactly what it costs.
Right.
I mean, it might
We know the
raise some
government doesn't
surplus.
do
It
that.
might raise some extra. So is it the purpose? If the purpose of the fee or the tariff is to raise money,
I
is
don't
it the
think
purpose that makes it revenue raising, or is it just the fact of surplus created that goes to the treasury? Like, how do we decide this?
Yes, I think it's the effect. And to be clear, I think there would be a serious difficulty with interpreting any of these words, even to allow revenue neutral exactions here, because none of them involve, and again, as far as I'm aware, IEEPA has never been used in that way. But I don't
Not
think
even a processing fee?
I am not aware of any use of that sort of under IEEPA. But even if that is permissible, I think that's permissible precisely because it doesn't have the effect of raising revenue.
Mr. Katyal referred to common sense several times, and I want to pick up on Justice Barrett's question because your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects, but you're admitting that power's in there.
Yeah.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that.
Okay. All right. Don't believe your lying eyes. It's not a donut hole. It's a different kind of pastry. Fucking what?
That was a weird.
That was a weird answer. All right, our last part, ladies and gentlemen, our last little part is just shy of 2 minutes, and it is Justice Sotomayor. And it is at the 4:28:45 mark. Oh, I had it, and I missed it. Did you guys see that?
I did.
4:28, 4 hours, 28 minutes, 45 seconds. Yes, Sean watched it all.
Took me 3 hours.
Good. Thank you. Thank you. We do appreciate it, guys. Let them know in the comments how much you appreciate the fact that he is doing this for us. All right, we got about 2 minutes, just shy of 2 minutes. We're going to go to the 4:30:30. 4:30:30. That's where we're ending it, and then we'll wrap up. Here we go.
Answers 201, 301, 230.
Counsel, I
That's a good
think what
point.
we're forgetting here is a very fundamental point, which is the Constitution is structured so that if I'm going to be asked to pay for something as a citizen, that it's through a bill that is generated through Congress and the president has the power to veto it or not. But I'm not going to be taxed unless both houses, the executive and the legislature, have made that choice, correct?
That's exactly right.
So there is something, it's not just the taxing power, qua taxing power. The question is, do we permit the president to use the taxing power to affect his personal choices of what is good policy for me to pay for?
That's exactly right. The question is who decides.
Who decides and under what circumstances? Now, with respect to this, I mean, I'm not even going to the pretext argument, okay? But the president threatened to impose a 10% tax on Canada for an ad it ran on tariffs during the World Series. He imposed a 40% tax on Brazil because its Supreme Court permitted the prosecution of one of its former presidents for criminal activity. The point is, those may be good policies, but does a statute that gives without limit the power to a president to impose this kind of tax, does it require more than the word regulate?
Exactly.
That's your point.
Yes.
Thank you.
Okay. That really sums it up. Your point is this should require more than the language that's currently in there. I want to do something real quick though, guys. What IEEPA, is that what it's called?
I think that, yeah.
What is
It's the
IEEPA?
International Emergency Economic Power.
Yeah, here it is. All right, guys, I'm gonna share with you what I'm looking at here. Here we go. I looked up IEEPA, refer to several different things, but this is what they were talking about. International Emergency Economic Powers Act. It's IEEPA. A U.S. law giving the president power to regulate international economic transactions during a national emergency. Oh, that's very interesting. That is very interesting wording right there. Okay, so if we go with IEEPA and see, 1977 U.S. law that gives the president broad authority to regulate international economic transactions during a national emergency. It allows the president to take actions such as imposing sanctions, freezing assets, or restricting trade to address threats to national security, foreign policy, or the economy. For example, the law has been used to authorize tariffs on imported goods in some situations, though its use for this purpose has been legally contested. So that's what they're arguing about. Let me see. Did Nixon impose tariffs? There it is. Did Nixon impose tariffs? Yes. President Nixon imposed a 10% tariff in August 1971 as part of his new economic policy to address the collapse of the Bretton Woods system and the declining value of the dollar. This 10% surcharge on most imported goods was a temporary measure designed to protect the dollar, improve the U.S. balance, etc., etc. The tariff was lifted in 1971 after the Smithsonian Agreement was negotiated. What is the Smithsonian Agreement? 1971 International Monetary Agreement to devalue the U.S. dollar against gold and revalue other currencies against the dollar. In other words, it took us off the gold standard. It was an attempt to stabilize the global monetary system after President Nixon suspended the dollar's convertibility to gold, but the agreement collapsed by early 1973, etc., etc. It goes into a lot more detail, but yeah, but ultimately, yes, Nixon did tariffs. Congress had no problem with it. As a matter of fact, IEEPA was after Nixon. So
yeah, it was during Carter.
During Carter.
1977. Yeah, Carter was.
Yeah. When was Carter president?
77. Yeah.
77 to 81. Called it. Yeah, look at that. I remember my grandfather. He did not like Carter at all. My grandfather, I called him Pawpaw. He would say, "That man does nothing but what did he say? Scratch his ass and eat peanuts." I don't know where the scratching his butt came from, but that was what he said.
I think he was sincere, but he was over his head.
Oh, vastly over his head. Vastly over. I don't mind Carter. As a matter of fact, I think Carter is one of the few, like you said, good-hearted. I think he went in thinking he was going to do what it turned out that he couldn't do. He was in way over his head, I believe.
He's one of the two presidents that I've seen speak live.
Really?
Carter and Trump.
Fair enough.
Yeah.
Wow, I didn't know you saw Carter.
Yeah, he came to I was a Mennonite at that time, and it was a Mennonite youth convention in Atlanta in 2000.
I'm learning all kinds of stuff today, man. I didn't know you were a Mennonite at one point.
Oh, yeah.
Oh, interesting. Man, that would make for a cool episode. But you ever see the Amish Mafia? About the show about the Amish Mafia?
I've never seen it, but I've heard of it.
Yeah. So I heard a lot. I don't know anything, so I'm not going to go. I've heard a lot of stuff, but that's it. I don't have anything. So, all right, guys, listen, I appreciate you taking the time to watch. Hour and a half from 4.5 hours. It's a pretty good reduction. It's a pretty good reduction. Thank you, Sean. As always, you're very welcome here, and we appreciate the time that you put into this.
You're welcome.
It's going to be really interesting to see the way that they rule, because I could see it going either way.
I think it's going to go that they're going to want the Congress and the president to work together.
Yeah. I mean, they should be. Let's face it. But at the same time,
okay, were you going to say?
I was going to say at the same time, you have these people that their entire what's the word I'm looking for here? The thing you run for office, you got your list of things you want to do. Their priorities. There's another word. Anyway, the only thing they care about is going after Trump. The only thing they care about is defying Trump, impeaching Trump, hating on Trump. Just do your job, guys. Just do your freaking job.
Every single thing that Trump tries to do. That's going to be the
problem
too.
Yep. Yeah, they wouldn't even look at the government shutdown. That's a perfect example. And I personally was shocked at the election results that came in during that time, because I don't understand it. Yeah, I figured there would be a few more intelligent people out there that saw what the Democrats were doing, but to each their own, man. To each their own.
And Virginia are blue states.
Yeah. I mean, we'll see what happens. The midterms are going to be really interesting, I think.
They are.
Very, very interesting. Just out of curiosity, we'll end it with this. What would you like to see? Assume that the Senate turns red, House stays red. Well, that they have 60. I know it's not going to happen, okay. but let's just say for a moment that 60 votes in the Senate now, plus House
House supermajority too?
Supermajority in the House, and the president can enact whatever he wants. What would you like to see him do?
What would I like to see him do? Never really thought of let me think. I wish we could audit the Fed.
Ding,
But
ding, ding. I like
I
that
don't think
idea.
there's even when there's 60 Republicans in the Senate,
They won't
that
do
would
it.
happen.
No.
So we're gonna gotta be realistic.
Yeah, audit the Fed, I'd really like to see. So Trump was talking about Fort Knox, right? So allegedly, he got a report that the gold was there. Okay. Allegedly. However, him and Elon both promised that they were going to go check. I haven't heard him do that yet.
I haven't either. And Senator Rand Paul was gonna go there too.
Yeah, he was going to go too. So keep an eye on that. I'm curious. I'm curious if it's actually there. Just because, not because of anything individual other than our government lies. They lie. They're full of crooks. We know this. And I'm not blaming anyone in particular. And both parties are corrupt as shit. So let's get that perfectly clear. It's not a blue versus red. It just is a thing. Our government is corrupt. So we know that at any point, some people could have done some shady stuff easily. I'd be interested to see if they pulled it off or whether, we're good. We're going to do your next day that you're available. I would really like to do a light tinfoil hat episode on, Fort Knox and the theories surrounding it. And
do that.
There's some really interesting conspiracy theories out there regarding Fort Knox.
And then I got a message while we were doing the show real quick that they did decide the Indiana General Assembly is going to meet next week.
Oh, so they are going to meet for the redistricting. All right, guys, listen. If you live in Indiana, make your voice heard. If you're against redistricting, let them know. If you're for redistricting, let them know. Call your rep, call your senator. If you don't know how to reach them, let me know. I will get you the list. It's not hard. If you go, as a matter of fact, if you go to, I'm going to bring it up just so I can make sure I have it right.
And do you want to do the hearings for that for a show?
Yeah, I would really like to because I think that we can learn a lot about watching that. All right, so there's all in here. Let me show you guys what is here. All right, so this is in.gov. And if you go up here to the top left, here, I'm going to move us down here. If you go up here to the top left, residents, there's apply for state jobs, professional licenses, outdoor education, etc., government. There we go. So courts and judiciary, laws and administrative code, election division. There's how you reach the governor. There's General Assembly. So let's click on General Assembly. This is kind of small. Let's take a look. All right. So there's our calendar.
Yep, December 1st. It's on there.
Session, committees, laws, publications.
You see it up there.
Yep. We'll reconvene on Monday, December 1st, 2025 at 2 p.m. All right.
Whatever they decide, it's fine and stuff. I was just upset that they weren't even going to have the debate.
Right. That's the thing. Just vote.
Yes.
Like, you don't have to pass it if your people are against it. If you're hearing nothing but people calling your office saying, no, vote that way.
Yeah.
But put that shit on record. Do your job.
Exactly.
The governor called a special session. Get your asses to work. It's that simple.
Yeah, you're supposed to be working for us.
Yeah, you're supposed to be doing your damn job. So let me, there it is. Find your legislator. Okay, so it's right here on this page. And it says right here, find your legislator. You click on that. And at the top, I'm going to put you down here so you can see. At the top, it has iga.in.gov/information/find-legislators. It's a little more complex, but if you put your address in right here, it will take you You know what? I'm going to put my old address in.
So, quick
So,
question.
yeah, this is where I used to
Was-
live. I don't live here anymore, so I'm not doxing myself. Go ahead.
You know, my state rep resigned. Can they
Yeah, so the state
Is
rep.
he officially?
Yeah,
He was
Randy
sworn in?
Novak is the new state rep,
Okay.
and he has been sworn in.
So he will be the one that told the Indy for this.
Yes, yes. So I used to live at Providence Street in Michigan City. So yeah, the senator is Rodney. If you live in Michigan City, your senator is Rodney Pohl. Your representative is Randy Novak, and then unfortunately for you, your congressman is Frank Mervan. Your senators are Todd Young and Jim Banks for federal. But for state, Rodney Pohl are, you can call by all means. If you're for redistricting, you can call Rodney Pohl, but we already know how he's going to be voting. Same thing with Randy Novak. By all means, make your voice heard. If he has nothing but 5,000 people calling him, telling him to vote for redistricting, that'll be an interesting day. Put it that way. That said, once again, in.gov, and you can go to legislators and find my legislator and put it right in right here.
Yeah, I'll have to do the timestamps for when they do this.
Yeah, yeah. We will for sure be bringing you guys that at Sean's earliest convenience, and I think we'll also do a couple of tinfoil hat episodes if we can.
That fit the tinfoil because the Doge committee
Mhm.
earlier this year did a hearing on weather modification and how the government's doing. So we could do that too.
Yeah, I see. I've heard about that stuff for many, many years, and it's been fringe, right? You have these people that are like, "Oh, they're poisoning our kids," and it's like, okay, what evidence do you have of that? Because I'm concerned. Oh, well, there's stuff in the air. What stuff? Like, what are you talking about? Well, it's the trails. Are you talking about contrails? Because contrails are different than, what do they call them? Chemtrails? They're two different things. So then you get those people that think everybody that's talking about chemtrails is actually mistaking contrails for them. And no.
But yeah, they did an actual hearing about it.
Interesting. Yeah, we should totally, we should dive into that. All right, guys, we are going to be out. I should actually just have time to get this live. So
cool.
All right. Without further ado, ladies and gentlemen, God bless you, God bless Indiana, and God bless the United States of America. I hope you have a wonderful evening, and we'll see you again real soon. Good night.